The Senate Judiciary Committee chamber was steeped in a quiet anticipation, the kind that makes even the most seasoned reporters straighten in their seats. Governor Ron DeSantis leaned forward toward the microphone, his expression a mixture of confidence and precision, like a chess master setting the board. For nearly 15 minutes, he had systematically dissected Representative Jasmine Crockett's proposed Federal Voter Protection Act, invoking state sovereignty, constitutional precedent, and carefully curated statistics that seemed to undermine her arguments before she had even spoken a word. "Representative Crockett," DeSantis's voice echoed through the room, smooth but firm. "Your bill seeks to federalize election procedures the Constitution explicitly entrusts to the states. But tell me directly, can you name a single provision in your home state's election laws that prevents any legally eligible voter from casting a ballot?" A hush fell over the room. Committee members shifted uneasily. Reporters leaned forward, sensing a trap carefully laid. Crockett remained motionless for a heartbeat, her eyes scanning the governor with an unreadable expression. Then, with the calm precision of a trial attorney, she reached for her microphone. "Governor," she began, her voice measured, unwavering, "I have here the transcript of your sworn testimony in Davis versus Florida from last year, where under oath you admitted that certain provisions in Florida's election laws could potentially hinder eligible citizens from voting. Shall I read your exact words to the committee?" DeSantis' confident smile faltered. If only for a moment. Whispers rippled across the room. What followed was not the typical political sparring. What unfolded was a confrontation that would reshape the national discourse on voting rights and executive power. Crockett, a graduate of the University of Houston Law Center and a former civil rights attorney, had spent her career defending voting rights across the South. At 42, she had argued multiple cases before federal appeals courts, earning a reputation for composure under pressure and unrelenting precision. Her Federal Voter Protection Act was not a partisan gambit. It was the culmination of years of research and advocacy. Unlike earlier efforts, this bill was surgically precise, crafted to eliminate systemic barriers affecting vulnerable populations while respecting legitimate state interests. "This is not about politics," she had said. "It is about guaranteeing every eligible American the constitutional right to vote, unimpeded." DeSantis, meanwhile, had cultivated a national image as a staunch guardian of state sovereignty and election integrity. A Harvard Law graduate and former naval officer, he had implemented some of the nation's strictest voting laws in Florida, defending them as necessary safeguards despite scant evidence of actual fraud. His appearance before the Senate Judiciary Committee was intended to solidify his leadership credentials and potentially position him for higher office. The confrontation was about far more than politics. It was a constitutional collision. How far does state authority extend in administering elections? Where does the federal government intervene to safeguard fundamental rights? For months, this debate had simmered, growing ever more pointed. After Crockett introduced her bill, DeSantis publicly decried it as unconstitutional, while Crockett cited Supreme Court precedent affirming Congress's power to regulate federal elections and enforce voting rights amendments. Their clash was intensified by the Davis versus Florida case, where DeSantis had been deposed on the very laws Crockett now sought to challenge. At 10 a.m., Chairman Whitehouse called the hearing to order. Today's session will examine SB 2731, the Federal Voter Protection Act, sponsored by Representative Crockett. Our first witness is Governor Ron DeSantis of Florida. DeSantis approached the witness table with methodical calm, arranging his papers and adjusting his notes as if rehearsing for a performance. "Thank you, Mr. Chairman," he began. "I appear before this committee to express serious concerns about legislation that would fundamentally alter the constitutional balance between federal and state authority over elections." For the next 15 minutes, DeSantis delivered a polished critique. Article 1, Section 4 of the Constitution, Historical Precedent, Federalism Principles, all were cited with precision. He extolled the virtues of state-level election administration, framing states as laboratories of democracy, and cautioned against federal uniformity undermining flexibility. Then he pivoted to statistics, charts, graphs, data points, voter ID requirements, ballot harvesting prohibitions, chain of custody procedures. Florida's turnout, he claimed, had risen across all demographics. Several Republican committee members nodded approvingly, impressed by his articulate defense. When Crockett was recognized for questioning, she approached with the measured grace of a courtroom veteran. "Governor, thank you for your testimony today," she began. "Happy to be here." "Representative," he replied, a faint smile crossing his face. "Governor," she continued, "you've argued state sovereignty is paramount. Would you agree that this sovereignty is not absolute and must operate within constitutional boundaries?" "Of course," DeSantis replied, nodding. "States must respect constitutional principles, including equal protection." "Then let's examine what's reasonable," Crockett said. "You testified that Florida's election integrity measures increased participation across all groups. Can you specify which measures you are referencing?" "Voter ID requirements, restrictions on ballot collection, accurate voter rolls, chain of custody procedures," DeSantis listed, voice steady. "And these measures," Crockett asked carefully, "did not negatively affect any eligible voters?" "Overall turnout increased," he responded confidently. Crockett tilted her head slightly. "Governor, do you understand the difference between correlation and causation?" DeSantis's expression tightened. "Yes, it's a basic statistical concept." "Then would you concede that other factors, political engagement, outreach, civic campaigns, might also influence turnout?" He hesitated. "Multiple factors contribute, yes. But the key point is, our laws did not suppress voting." "Governor," Crockett pressed, "even if 99% of voters face no barriers, constitutional rights protect the remaining 1%. Correct?" "Yes," he admitted, unease creeping in. "And yet today, you characterize your laws as obstacle-free. Can you affirm under oath that every eligible voter in Florida can cast a ballot without substantial obstacles?" DeSantis faltered, caught in a bind. He opted for nuance. "Our laws create a system that is both accessible and secure. Any eligible voter making reasonable efforts can vote." "Reasonable efforts," Crockett repeated, voice steady. "That's an interesting qualification." She opened a folder deliberately, producing the Davis versus Florida transcript. "Governor, in your deposition, you acknowledged that some voters, due to rural locations or mobility issues, face heightened challenges under your laws. Is that accurate?" DeSantis shifted. "Context matters. No system is perfect, but these are edge cases." Crockett's gaze sharpened. "Edge cases to whom? To a disabled veteran standing in line for hours? To a rural voter traveling miles for an ID? Are their rights theoretical?" The chamber leaned in. What had begun as a procedural hearing was now a confrontation about real people and their access to the ballot. She methodically presented affidavits. Mary Wilson, 78, traveling 67 miles to obtain an ID. James Hernandez, a paramedic, unable to vote due to limited Dropbox hours. Each story punctuated the human cost of laws DeSantis had defended. "The Constitution," Crockett concluded, "doesn't protect only those convenient to accommodate. It protects all citizens." For a moment, DeSantis was silent. The confident veneer cracked. The room, once tense with anticipation, now held the weight of undeniable truth. The chamber remained heavy with tension as Chairman Whitehouse called time. For a moment it seemed the weight of the confrontation hung in the air, refusing to dissipate. Reporters frantically typed notes, their cameras capturing every second. Governor DeSantis, usually unflappable, now faced a rare moment of vulnerability. He attempted to recover, reiterating that election integrity involved maintaining voter confidence, not just counting ballots. Crockett, granted an extra minute, leaned slightly forward, her calm intensity unbroken. "Governor," she said, "this isn't about federal versus state authority. This is about the Constitution versus laws that deny citizens their rights. You've admitted under oath that your measures prevent eligible Americans from voting. The question isn't state authority. It's whether that authority allows the denial of constitutional rights. You've admitted it does. That's the issue." The room fell silent. Even seasoned senators shifted in their seats, recognizing they had witnessed something extraordinary. A debate stripped of partisan theater, reduced to its constitutional essence. Video feeds captured Crockett's precise dismantling of DeSantis's argument, her methodical exposure of the contradictions in his own testimony. By evening, the exchange dominated political coverage across the nation. Headlines praised Crockett's use of evidence over rhetoric, clips of her presenting affidavits of affected voters, and quoting DeSantis' own deposition circulated widely on social media. Even traditionally conservative outlets acknowledged the force of her approach, highlighting her precision, preparation, and constitutional focus. For DeSantis, the aftermath was delicate. His team initially dismissed the confrontation as political theater, but public attention and the clarity of Crockett's arguments demanded a different approach. 3 days later, he appeared on a cable news program with a moderated tone. "I stand by Florida's election integrity measures," he said carefully, "but I recognize the need to ensure all eligible voters can participate fully. Representative Crockett has raised points worth considering, and while I disagree with federal intervention, we must continuously improve our implementation." Observers noted the subtle shift. Political scientists described it as a rare acknowledgement of accountability, a strategic recalibration to preserve credibility. For Crockett, the hearing elevated her profile nationally, but did not change her disciplined approach. "My role isn't to generate viral moments," she explained. "It's to ensure our laws uphold constitutional promises to every American. That requires preparation, evidence, and principle over personality." The impact extended beyond headlines. Florida's legislature, reconvening months later, enacted modest but meaningful reforms addressing barriers Crockett had highlighted. Expanded ID options for elderly voters, extended drop-box hours, and improved access in rural areas. Though DeSantis did not publicly link these changes to the congressional hearing, political analysts recognized them as a tacit acknowledgement of vulnerabilities exposed during Crockett's questioning. Other states followed suit. Election law reviews increasingly incorporated accessibility impact assessments, evaluating how new regulations affected diverse voter populations. A bipartisan coalition of election officials established the Accessible Democracy Initiative, dedicated to identifying and removing barriers disproportionately affecting vulnerable communities. Crockett's original bill evolved through dialogue with legislators from both parties. Modifications preserved constitutional protections while allowing states flexibility in implementation, creating a viable legislative path that had previously seemed unattainable. Legal scholars hailed the exchange as a masterclass in constitutional oversight. "What made the Crockett-DeSantis confrontation historic," noted a professor at Georgetown Law, "was Representative Crockett's insistence on substance over spectacle. She exposed the gap between stated principles and demonstrated consequences, forcing a rare reckoning in constitutional federalism debates." 3 years later, when a major voting rights case reached the Supreme Court, justices cited the evidence from the hearing. The majority opinion referenced Crockett directly. "The Constitution protects all Americans, not just those convenient to accommodate." Her words, once delivered in a tense congressional chamber, became guiding principles for judicial deliberation. For ordinary Americans, the confrontation clarified a complex issue. Retired teachers, young voters, and rural citizens watched the hearing and understood something previously abstract. Voting rights aren't theoretical. They are lived experiences, and laws that obstruct them, even unintentionally, carry real consequences. DeSantis emerged from the encounter more cautious but politically seasoned. Subsequent public appearances showed restraint. Absolute claims about election law were replaced with nuanced acknowledgement of the need for accessibility. This measured approach enhanced his credibility with moderates, demonstrating growth in understanding the limits of executive authority. Crockett continued to exemplify methodical, evidence-driven oversight. Invitations to speak at law schools, the American Bar Association, and conferences on voting rights poured in. Scholars and policymakers studied her strategies as examples of precision, preparation, and commitment to constitutional principles. The lasting legacy of the confrontation was neither a partisan victory nor a simple policy win. It was a reminder that effective oversight requires more than rhetoric. It demands evidence, preparation, and principled confrontation of reality. In an era dominated by theatrical politics, the Crockett-DeSantis exchange offered a rare glimpse into substantive constitutional debate. It demonstrated how careful, fact-driven examination could hold power to account and advance public understanding of complex legal and civic issues. For many Americans, the exchange reaffirmed a fundamental truth. Democracy depends not on convenient assumptions, but on the rigorous protection of rights for all citizens. Representative Crockett's methodical approach showed that even the most entrenched systems could be challenged, not with theatrics, but with precision, preparation, and courage. In the end, the confrontation transcended politics. It became a blueprint for constitutional engagement, a testament to the power of law and principle in shaping the nation. Crockett's closing words, "The Constitution protects all Americans, not just those convenient to accommodate," echoed far beyond the hearing room, leaving a permanent imprint on legal discourse, electoral reform, and public consciousness.